All right. Hey, we're live. We've got 0 viewers at home. Okay. So it could just be the 7 of us. Who knows? So I think I'm allowed to give away 3 A's. So if y'all could just flip a coin, tell me who got heads. Heads is the A. Best. There you go. There you go. All right. Oh, we got a viewer at home. Hello, viewer at home. Hello. Let's hope viewer at home has a good sense of humor. All right.
Usually for
Yeah, thank you. All right. Knew there had to be something. Hello. Hey, how you doing?
doing good.
All right.
Let's see.
Welcome back.
And please forgive the email.
Why are you sitting? Oh, which one was yours?
Well, I'm Clint.
Oh, hey.
Professional responsibility.
I know from the voice, right?
Yeah,
Sorry for not knowing from the face. Man, those little pixels are small on the screen.
I could keep off on that, but I won't. I'm pretty sure you know what you like. But
No doubt.
the email that I sent you, I was requesting some materials unrelated to this book. Your email just so happened to come in, so when I clicked respond, it was for another professor.
I figured that. I figured it was for another.
I've made 2 email mistakes, and you think that I was double checked before sending, so I'm sorry about that.
It's all good, man.
Thank
It's all
you.
good. It's weird, like I figured that's what was going on.
But since I'm already so tall too, if it's
Middle road is off.
yeah, middle side. I don't think you know.
Yeah, I did that when I walked in. I looked at the front row. I'm like, oh, nobody else is there. I can't do that.
Oh no, you can. If you're learning, I do this, yeah. If I have my screen, be too close to. I love learning. Bottle will be behind you. Yeah, that's right. Because you know she's blind. She's blind.
Wow, way more than I thought it would be.
Oh, is this a big turnout? All right. Oh, go to YouTube. Yeah. Yep, it's broadcasting now. I'm waving at the screen. It says there's 11 people watching, so it can be done. All right, good luck.
This notes of like nine, it's like Wednesdays, so like 91. Good, wakes me up. And bar survey, or bar essay at night. So it's like course. And basically, you'll basically have a night for bar essay that morning. They have two of them one day. So I can read that one, but
Anybody need the surface cleaning home? Okay, I'll put it over here.
You almost need like two cameras, one to put there, one to.
Wouldn't that be great? And then like a couple of camera persons, right?
Yeah.
Maybe like
A
one of
nice
those boom
microphone,
with the boom mic. That would be nice.
That'd be
Yeah.
real nice.
And then a little like post production, like when I go from part A to part B, they could clip in a little.
Yeah, like an explosion behind.
Oh, like an explosion behind. Oh, now we're talking. Now we're talking. I don't know who to talk to about getting these graphics, but they would be perfect. All right. Okay.
Holy crap, dude. Yeah, the mask's like high. Yeah, I haven't seen you in a year.
Welcome, everyone. Welcome. First of all, for those of you who are here, thank you for being here. For those of you who are at home, hello. Thank you for being here, too. So it's good to see everybody. Just want to make sure everyone's here in the right room, in the right place. This is Advanced International Antitrust Part 2. Is that right? No? Just kidding. All right. It is, as the big board says, Florida constitutional law. Yes, you've studied the Constitution, but you know what? Florida's got one, too. Yeah, all 50 states have one. District of Columbia sort of has one, because Congress passed it in the statute there. And, of course, we have 16 territories, and almost invariably,
they've got a constitution too. So, hey, you've studied the national constitution. Good for you. But there's 57 others you still got to cover. Well, no, we're just going to cover one. We're going to cover Florida's constitution. So hope that's enough. Hope that doesn't disappoint. And there will be no coverage of antitrust law. So sorry about that. Sorry about that. That would be another class. But by way of introduction, my name's Patrick McGinley, but enough about me. This class is not about me. This class is about you. And I mean that. I really do. You know, this class is a continuation. It's building upon the knowledge you've gained and learned in studying the federal Constitution. But I want to go beyond that. I want this class to be, to use a euphemism or an analogy, where the rubber meets the road. I want this class to be a practical class. I want this class to be about using your constitutional law knowledge. Now, if you hang around here on campus, you have not seen me. I am not a member of the faculty of your law school. Therefore, I guess you could say I'm not a law professor. Anybody in here a law professor or want to be a law professor? Raise your hand. No? Okay. All right. What I am is an attorney. Anybody here want to be an attorney or is an attorney? Want to raise your hand? Okay, good. So maybe if you came here to become a professor, maybe I'm disappointing you. If you came here to become a lawyer, maybe I have something to add. And that's exactly what I intend to do in this class. And in this class, we're going to talk about constitutional law. We're going to talk about big topics. We are not going to avoid the big topics. This is a class where we take on the big topics head on. We don't avoid big issues. For example, we're going to talk about abortion. We're going to talk about privacy. We're going to talk about sex and sexual relations. We're going to talk about euthanasia. Youth in Africa, youth in Europe, youth all over the world will be covered right here in our class. But we're going to do it with a little bit of humor. And I mean that quite literally because my jokes aren't that funny. So just a little bit of humor. And I know when you hear one of my jokes, you say to yourself, that was sort of funny, but it really wasn't funny. I'll just hold my laughter till the next one. Don't. It's the best I got. So go ahead and let that laughter rip. So, and although I attack these topics with joy and with humor, I understand the severity of these topics. I understand that there is injustice in this world. Those of you at home, I can't see you raise your hand, but those of you who are here in the classroom with me, if you've ever met someone who told you about someone who suffered an injustice in this country, would you raise your hand? Keep that hand up for a moment, please. Have you ever met someone and that person themselves suffered an injustice in this country? Raise your hand. Keep that hand up. Join these hands. And sadly, if you yourself have ever been the victim of an injustice in this country, raise your hand. Raise your hand. And those of you at home, I'm going to have to turn the camera around, but keep those hands up and go ahead and look. Look to your left. Look to your right. What you see is an ocean full of hands. And the reason you see all these hands is based on a simple reality. Yes, there is injustice in this world. And you have to believe that because you could see it. You could feel it. And God forbid, you could be the victim of it. So you have to believe that there is injustice in this world. But you know what? There's something else you can believe. And I believe it for the same reason that I believe that there is injustice in this world. I believe this second thing because I've seen it. And I dare you to think about it, because I think if you think about it, you'll agree that you too have seen it. What I've seen, and therefore what I believe, is that the Lord our God has not abandoned us and our fellow humans to a world of injustice. Instead, what I see time and time again, semester after semester, courtroom appearance after courtroom appearance, what I see is that individuals have answered the call, that they have come forward and they have decided that for themselves and more importantly for their clients, they will be the difference between justice and injustice. What I've seen are individuals with great skill, great knowledge, great education, put those careers on hold, get postgraduate education, and learn to be more than just a pundit who can lament that there are injustices in this world, but instead learn how to do something about those injustices. These individuals I've seen literally carry the cross of their brothers and sisters in that fight for justice. Society has given a name to these individuals. We call them attorneys. We call them lawyers. And you can choose to say, well, there's McKinley getting all romantic about it. It's just a profession like any other. And if you choose, then that can be true for you. But what you can also choose is to make our profession something even greater. That's the challenge I present you with in this semester. But I don't abandon you to meeting that challenge alone. I have worked very hard, and if the Lord wills it, I've succeeded in putting together a textbook, a curriculum, a series of lectures, and a way of presenting this material that I hope and pray will be beneficial to you. At a bare minimum, I intend to make you so well versed in Florida's Constitution that when that inevitable essay question arises on the Florida bar exam, you will score so many points on that question that you'll not only pass the exam for that question, but you'll have extra points to make up for any lackings in any other areas. But that isn't my ultimate be-all, end-all goal. That isn't why I'm here. Why I'm here is to quite literally empower you. I am here to empower you. What do I mean by that? I'm here to give you the skills that you need to carry the crosses of your clients, to do something more than just lament about the injustices of this world, to be the person who can make the difference between justice and injustice, and to make justice where it is necessary. This is not a vague promise. I intend you to hold me to it. Those of you at home, you need to hold me to it too. You're watching through YouTube. This is on video. Play it back and quote it to me anytime you'd like. Because I intend to meet this challenge I've given myself. For example, before this month is over, not before this class is over, I know it's the middle of the month already, but before this month is over, you will know how to fill out the forms, follow the procedures, and alert the EEOC, Equal Employment Opportunity Commission, and the FCHR, Florida Commission on Human Relations, to a potential employment discrimination violation that violates the constitutional rights of that employee or former employee. I will empower you to literally get a government agency to investigate, question, and look at a private employer's behavior to determine whether constitutional rights were violated. And I will do that before the month is over. Mark my words, hold me to that promise. I won't stop there. I will teach you what to file. I will teach you where to file it. I will teach you how to file it. And I will teach you the skills you need to make a difference in this world. When you're done with my class and done with the others, you will receive your Juris Doctor, your JD. And if you work hard, and the Lord wills it, you'll pass the bar exam of your choice. At that point, that's when you have the real decision to make. When you hold that law degree in your hand, that's when you decide whether you're going to make a difference in this world. I'm going to empower you to answer that call with a resounding yes. Now, you're going to have to listen to 23 hours of my lectures. I apologize for that in advance. But hey, you got to do what you got to do to get the JD. Am I right? As you hear my lectures, you'll notice that I am a man of many flaws. It's hard to hide them all when you have as many as I do. Not the least of which is that I wear my faith upon my sleeve. Now, for many people, that's not a flaw. It's a beautiful thing. But I admit that for me, it is a flaw. Because if I really was this great Christian that I go around claiming to be, I would never have to tell anyone that I was a Christian. You would just know it from my behavior. Am I right? Correct me if I'm wrong, but what is Christian? Is it what one says? Or is it what one does? The sign of a Christian, is it what she or he holds in her or his heart? Or is it those gifts of the Holy Spirit that come forth from a true Christian? So I apologize that I go around mentioning Jesus and his beautiful mother Mary at every moment that I can. But as I teach these kinds of topics that we address here in a constitutional law class, I can't do that in good conscience without also addressing the morality of the situation. And for me, my morality is a Christian morality. I'm proud to be a Catholic, and I will share with you what I believe to be the wisdom of God's church, his one holy Catholic and apostolic church, as it has been passed down from the apostles to the present. Now, I understand that we all come together through different faiths, through no faith at all. And I love and respect your choice of faith. I hope you don't mind that I share mine. And by sharing my faith, I'm not trying to say that I am better. To the contrary, I've already admitted to you, I'm a man of many flaws. And if you think I was exaggerating, just hang out with me for the next 26 hours. You'll see many of those flaws. But I want to share with you not only the knowledge you need to succeed in the practice of law, but I want to share with you some of the moral issues that arise in a topic such as constitutional law. Those moral issues are unavoidable. And as I said earlier, I will not avoid those issues. Now, your faith is different than mine, and I respect it. My goal is not to convert you, but you have come here to a Catholic law school. So why not check out Catholicism? I give as an example, an analogy, but a true life one. My buddy Mikey Starks went to law school with him. If he's willing, he'll be a guest lecturer at some point during the semester. A brilliant man. And I've kept in touch with him throughout the years. I remember very many years ago, he journeyed to France. Anybody been to France? I've been to Paris, haven't seen much of France, but I saw Paris. It was my honeymoon, so I saw Paris, and, I saw my wife, and I saw Paris, So I'd love to get back to France. And Mikey, he managed to travel throughout France. And another thing you need to know about Mikey is the man loves McDonald's. Anybody here eat McDonald's? Yeah, and he was so excited to tell me about the McDonald's he enjoyed in Paris at the Champs-Élysées as he drove through the countryside, and he went to various McDonald's, and how the menu at the McDonald's was in French, and how the French fries, you could dip them in mayonnaise. And I had to interrupt Mikey, and I had to ask him, Mikey, I know you love the McDonald's, my friend, but you're in Paris. Did you happen to try the escargot? Did you have a crepe? Did you check out the local cuisine? Why wasn't Mikey eating the local cuisine? Was he afraid that if he ate the crepe or the escargot that he would suddenly become a Frenchman? He shouldn't have such fear, right? Checking out the local cuisine doesn't transform you into a local. And I use this story, this analogy to raise this point. You're here at a Catholic law school. And in this class, you'll get the chance to check out Catholicism. It doesn't necessarily make you a Catholic, nor does it need to. But just like Mikey, who drove through France, eating Big Mac after Big Mac, or Le Big Mac, I guess, why not stop and try the local cuisine? So here I am. I'm your friendly neighborhood resident Catholic lawyer, and I'll share a little Catholicism with you along the way. So I hope it doesn't offend, because it's not intended to. To the contrary, I hope it helps to brighten and enjoy your experience here at a Catholic law school. Just as, no disrespect to my buddy Mikey, I think he would have enjoyed the trip to France better if he'd tried a little escargot and a couple of crepes along the way. Make sense? All right. And while we're talking about my flaws and rattling off my apologies, invariably, I begin every class with a prayer. A Catholic prayer, because I'm Catholic. I will be praying for you. And I'll be praying about you. And this last part is up to you. If you'd like, I'll be praying with you. Because if you'd like, you're always free to join me. Catholic prayers are beautiful poems, beautiful rituals. The words come to us from time immemorial. Those are the ones I tend to like best. For example, this one goes like this. In the name of the Father, of the Son, of the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Come, Holy Spirit, and speak through me. Now, I'm not worthy of it, but these students, they deserve nothing less. Amen. In the name of the Father, Son, Holy Spirit. Amen. All right. So let's start at the beginning, shall we? Tell me a little bit about yourself. Perhaps you're a 2L. Perhaps you're a 3L. Perhaps you might say you're a 4L, right? Yeah, maybe even a 5L. Oh, a 2L. Raise your hand if you're a 2L. All right. Any more? 3L. Raise your hand if you're 3L. All right. Sounds great. Might call yourself a 4L. Go ahead and raise your hand. No? Okay. All right. Yeah. Now tell me about this. You studied the federal constitution. You took federal con law, right? Thank God. Okay. Because if somebody said no, I would have to tell you that that's a prerequisite for this class and you shouldn't be here, which is not my decision to make. That's your faculty, your administration. All right, so good. You've all taken Con Law 1. If you haven't, don't tell me. All right, no, seriously, you got to take that first. All right, but now where would you put your understanding of constitutional law? I got the frowny face over here, all right? This would be the person who really isn't sure how to spell the word constitution or where to find a copy of it, right? Okay, and then you got the big grin over here, right? Who's this? This is, I don't know, Chemerinsky himself. I don't know, who is that? That's someone, maybe they were there with the founding fathers and helping them write it. I don't know. Who's that over there? And probably the rest of us are somewhere in between. Who would like to tell me where they feel they are? Where do you feel you are? Yes.
Probably that orange guy.
You're gonna go orange. Yeah. Orange is a lot closer to red than it is bright green.
I hope to be over there.
You want to be over here. Okay. All right. Well, hey, I respect that. What I find is that different folks have had different professors for Con Law 1, right? And, in Con Law 1, there seems to be two different goals going on, okay? There's two different objectives going on. The first, and I hope the foremost, is to teach you the concepts you need to know as a practicing lawyer and as a potential bar exam taker about the federal constitution. But the other is that they're also trying to teach you how to read case law precedent and interpret the law from the precedent. Did you notice there's the two things going on there in the typical Con Law 1 class? Does that describe your Con Law 1 class? Did that describe anybody else's Con Law 1 class? Okay. And what I noticed, there can be an imbalance sometimes. Depends on your professor, depends on that professor's semester. Sometimes you come out of there and you're great at reading case law precedent and distilling relevant legal doctrine from that precedent, but you really didn't get the doctrine that they were trying to teach. On the flip side, sometimes I see the opposite. You know, you've got the doctrine, but you just have no idea where that came from that case law precedent. And this is a particularly marked M-A-R-K-E-D event in federal common law, because unlike studying the UCC, right, you're not looking at a statute primarily and learning the law. You're looking at a bunch of ad hoc decisions that come together and create legal doctrine, right? Did you notice in your federal common law class, a lot of times you never read the federal Constitution? Correct me if I'm wrong. When you went to class, did you have a copy of the federal Constitution with you in Common Law 1? Yeah, right. Was it even on the curriculum? Or was it more like, well, there was this decision long, long ago in a galaxy far, far away that created law, and then there was another decision that tried to apply the first decision. Then there was a third decision trying to distinguish the second decision but still uphold the first decision. Then there was that fourth decision that was trying to rectify the second and the third decision but still uphold the first decision. And then this is what federal common law looked like, right? And I'm aware of that. And my goal is to teach this class differently. If you left your federal common law 1 class dazed and confused, you're not alone. But you will not leave my class dazed and confused about Florida's Constitution. You will not. Tell me more about your study of the federal Constitution. If today were bar exam day, would you nail the federal common law questions? Let's picture this face as F. Let's picture this face as A. So we got A, B, C, D, F. Where would you be on the federal? Yeah, go ahead. Thank you for sharing.
According to my common law professor, I'd be right that yellow face right there.
According to your common law professor. All right, so you're going here. Okay, and I appreciate the honesty, but you preface the honesty with, according to my common law professor. Yeah. Don't we make that mistake sometimes? We look at the grade on the paper that we got in law school, and we think somehow that this reflects our worth or lack of worth, our success or lack of success, our potential or lack of potential. Have you ever made that mistake? I tell you, I'm a graduate of the Florida State University College of Law. Started in 1993, graduated in 1996. And as I look back at my fellow 1996 grads, and I see the ones that with, 25, 30 years, whatever the hindsight, are clearly the most successful, those weren't always the individuals who got the greatest grades. I'll tell you more about them when it's appropriate to bring them up in our topics, but for example, there are 2 gentlemen who, as best of my knowledge, were not at the top of my class, but are certainly among the most gifted and talented civil rights attorneys of our generation. There's not a news story, there's not a noteworthy civil rights case where they haven't been involved. But yet they weren't, those 2 gentlemen, number 1 and number 2 in my class. Every night when I watch the news, and I gotta stop watching the news. I watch too much news, but I turn on Fox News at night and I watch Shannon Green, one of the most talented and gifted individuals when it comes to interpreting case law precedent. She was, before she had that show, and maybe she still is, the Supreme Court correspondent for Fox News. She can literally have on sneakers and be running back and forth from SCOTUS with a brand new, fresh opinion. And you know how thick a SCOTUS opinion can be. And as she's running back to the camera, she's not only reading it, but she's interpreting it correctly. She's amazing. But I know she wasn't either number 1 or number 2 in my class. So yeah, I heard what you said. You said, according to my con law professor, I'm right here. And I don't know who your con law professor was. I mean no disrespect to her or him. When I tell you, so what? Who cares what that grade was? You can achieve great things, regardless of what grade you might get in law school. I've seen it with my own eyes. I've got plenty of examples. I stopped at 3. I got dozens more. Where are the rest of you? Would you get all the federal con law questions right? Would you get the A on the bar exam? Or would it be a B, C, D, F? Or would it be? Well, I can't reteach all of federal con law in this semester. But I won't neglect to summarize it for you. I won't neglect to remind you of it. And in so doing, if you didn't know it the first time, then I'm teaching it to you, right? And I won't neglect to build upon those skills when it comes to interpreting, analyzing, and understanding the Constitution of the state of Florida. So with any luck, I can help you with that too. I'm making a lot of promises today, right? This is all on the videotape. Y'all at home, you got it. You got it on tape. Okay. Sorry, it must be annoying to the live people when I talk to. And the fact is, they're probably not there anyway. Right? They're probably not even listening. I didn't teach last semester, but the semester before that, which was the summer semester, and I see familiar faces. Thank you for coming back. Thank you for coming back. I don't know why you came back. Was there a 2-for-1 special? Buy one McGinley class, get one free?
Just a great professor, sir.
Well, thank you for lying like that, and I have the payment I promised you for that comment. Yeah. So, but no, in all seriousness, if you do survive a McGinley class, they have free therapy for you to help you recover. Just kidding. Just kidding. Okay. But, you know, I was teaching that class, and every now and then I would forget to turn off the video camera here after class was over. And often I was teaching it from my law office. So I'd get some coffee, do whatever. I'd walk back in a room. I'd be done with the lecture for 10 minutes, 20 minutes, 25 minutes. And I would look, and it would still say there's 3 people watching. Yeah. I thought to myself, are they really staring at my empty desk, or did they check out like 2 hours ago? Yeah. So if you are watching at home, I hope you're watching, is what I'm trying to say. All right. So now let's get to it. Our book is called Analyzing Florida's Constitution, and that's what I intend to do. It's a product of mine that I put my heart and soul into. It's the result of prior books that I wrote, which I hope were pretty good then, and I hope this is an improvement upon those. So I respect and would appreciate your feedback on the text, not right now, because you just started the class, but maybe after there's 13 lectures, maybe after lecture 11 or 12 or 13, if you give me some feedback. Because for me, it's a labor of love, and to the extent that I can improve it, I'd like to. So appreciate your feedback on that. But let's get started with chapter 1, shall we? Figure that's a good start. Chapter 1. And chapter 1 talks about federalism and state constitutions. Federalism and state constitutions. So we've got to talk about and just touch upon some political science here in our first lecture. And I'm going to try to do that without touching upon politics. But the line between politics and political science can be a thin one. So forgive me if, just like all my other flaws that I wear on my sleeve, that I happen to wear my conservatism upon my sleeve. I already mentioned that I was watching Fox News at night. Sorry, CNN watchers, that I'm not watching your station. But to the extent that the fact that I watch Fox, not CNN, makes me evil, despicable, or ignorant in your eyes, I apologize. But you can still maybe learn something from me. So, federalism and state constitutions. What do we mean by federalism as opposed to its opposite? And what word can we use for its opposite? Can we use statism, perhaps? What is federalism? Who here? Is there a poli-sci major? Typically, someone in my room is from a political science background. No? Okay, good. So when I misspeak, no one can catch me. Just kidding. No. Well, federalism talks about the fact, as we mentioned, that we've got 50 states, 1 District of Columbia, 16 territories, and these 57 areas come together, and that is our democratic republic. That is our federal system. But as you know from taking a class called Florida Constitutional Law, each state has some of its own laws. So what we're going to explore in greater detail, in greater depth in this first lecture is the interaction. We're going to explore and try to figure out, how do you put the two together? How do you put together the fact that we have a U.S. Constitution, but yet each state has its own constitution? If you're familiar with the U.S. Constitution, you know it to be the supreme law of the land, right? You know it to be applicable in all those states in the District of Columbia, in all 16 territories, right? So now, why then would a state have its own constitution? If we've got a federal constitution, the federal constitution is supreme, then why bother? Why do the states have their own constitutions? Why do state constitutions persist? Yes.
So according to your book,
According to my book, see, that I like. It's a great way to start any answer. If this were an essay exam, you just started with according to your book, and then I would give you an A. But of course, it's a multiple choice exam, so sorry you can't do that. But I interrupted you, yes. What's that?
You're going for the double brownie point. So according to your book, the state constitutions are the federal constitution, and a lot of the reason a lot of them probably still are standing is because they offer greater protection.
Yeah, that's a great answer, and it's a correct answer. Well, the first answer I mentioned in the order of page 1, chapter 1 there is the historian's answer. And what the historian would tell you is that at least for the original 13 colonies, which became the original 13 states, which became the birth of our nation, those 13 colonies had constitutions before we either had the Articles of Confederation or we had the U.S. Constitution. So the state constitutions came first, at least so far as the original 13 colonies are concerned. Now, that tells us where they came from. But does that answer the question as to why they still exist? I suggest no. So that's why I turned, in the next paragraph, to the pragmatist answer. Pragmatist, pragmatic. What does that mean, pragmatic? Like functional, right? Right? Being a pragmatist, looking at the result, right? So the pragmatist answer might tell us things such as that the constitutions are an organic source of law for the states. And what do we mean by organic? We mean like a first source. We mean like a source of authority. We mean like a basis for creating further laws. For example, we know that our federal government has a federal court system, correct? But I hope you realize that there's a state court system too, is there not? As I talk to you, I'm standing here in Orlando, Florida. Who knows where they are at home? Other states, other countries, other planets. But I stand here and you sit here in Orlando, Florida. So what court has territorial, has physical jurisdiction over a claim here? Well, obviously, the United States District Court for the Middle District of Florida has jurisdiction. That's a federal court. But that's not all. What about the Orange County Court? It too has territorial jurisdiction. What about the Ninth Circuit? And I'm referring to there, Florida's Ninth Circuit. It too has territorial jurisdiction. What about the United States Bankruptcy Court? It too has territorial jurisdiction. All four of those courts have territorial jurisdiction as I stand here today. What about in Atlanta? Could a court in Atlanta have territorial jurisdiction over me standing here in Florida? Why, yes. The appellate court, the 11th Circuit of the federal system, has territorial jurisdiction over both Georgia, presiding in Atlanta, and also including me standing here in Orlando. Is there any courts in the District of Columbia that have territorial jurisdiction over me standing here in Orlando? Yes, again. Whether it's the DC Circuit, if there happens to be a particular subject matter, if I have a tax issue here in Orlando, the United States District Court, the tax court in DC has jurisdiction. And of course, let's not forget SCOTUS SCOTUS, Supreme Court of the United States. SCOTUS, of course, has territorial jurisdiction over me. And I'll stop there, but I don't need to, because there is a litany of courts that have territorial jurisdiction over me standing here in Orlando, Florida. That's all part of federalism. And the pragmatist would tell us that when it comes to those state courts that are created under state law, the organic source of authority and jurisdiction for those courts is the state constitution. And the pragmatist would be correct. So does that answer our question? Is that why states have their own constitutions? And I say no, because I can point to other examples of nations where territories such as states have their own court systems, but their authority doesn't come from a state constitution. Think north, think cold, think Canada. Canada has the equivalent of states, but those territories, those states, if you will, do not have their own constitutions. There are clauses within Canada's national constitution that talks about the rights, duties, responsibilities, and powers of those subnational territories or states, but they don't have documents of their own. So the pragmatist answer does not answer the question of why we have, in the modern era, state constitutions. So that's where I bring you to what I like to call the sincerest answer. Faith on my sleeve, get ready now. There it is in your textbook on page 1 of chapter 1. Already, I'm turning to Catholic social teaching. And I'm turning to that doctrine of Catholic social teaching called subsidiarity. Look at the spelling and hopefully hear my enunciation of the word subsidiarity is different than the word subsidiary. I'm not talking about subsidiaries. If you've studied corporate law, you know that a corporation can have a subsidiary. That is not what I'm talking about here. The words may look similar, they may even sound similar, but they are not the same. I'm talking about a doctrine of Catholic social justice teaching called subsidiarity. And to get that definition, I can turn to no better source, in my opinion, than Pope St. John Paul II himself, who told us this in his encyclical Centesimus Annus. Subsidiarity means a community of a higher order should not interfere in the internal life of the community of a lower order, depriving it of its functions, but rather should support it and help to coordinate its activity with the activities of the rest of society, always with a view to the common good. I can state no better definition. It is both technically correct and beautifully stated. But with all due respect to the great Pope, it's a bit long-winded, is it not? So let me offer you a less precise, but far shorter definition. Subsidiarity means that local problems sometimes require local solutions. How about that definition? Not as all-encompassing, not as accurate, not as technically complete, but both easier to say and perhaps easier to understand. Is there anyone here who would disagree with me when I say sometimes local problems require local solutions? Any disagreement on that? Let's look at some examples. Let me reach for the easiest example that I can think of. The pothole. Talk about in a road. Talk about something you hit with a car. Talk about your street, hypothetically, has a pothole. No big deal. Think about our brothers and sisters who live paycheck to paycheck. Think about your neighbor living paycheck to paycheck who hits a pothole, damages their vehicle that they need to get to work, that they need to get the family where it needs to be, that they need to get the kids to school, that they need to earn a living. And now, because of that bill from hitting the pothole and living month to month, they've got to decide between fixing the car and putting food on the table, between fixing the car and buying medicine, between fixing the car and paying tuition. So let's not underestimate even the smallest problems, shall we? Okay, so your street's got a pothole. To illustrate the beauty of subsidiarity in a way which I don't think anybody can disagree with me. I'm going to start off easy, all right? What is better for you who lives on the street with the pothole and doesn't want the pothole? Would it be better if the decision maker who decides whether to fill your pothole now or fill it later or fill it never is the United Nations? Yeah, you've heard of the UN, right? They meet in New York, representatives of almost every, maybe every nation, right? We want all folks to be heard, right? All you got to do is get to the UN and convince them to fix your pothole. Or what if all you had to do was convince the president of the United States? That's all you got to do. Meet with the president of the United States, convince him to fix your pothole. Or what if all you had to do was convince the governor of Florida? Just got to go to Tallahassee, get on the governor's agenda, right? Or what if all you had to do was convince City Councilman Susan, who also lives on your street? Be honest with me now. Which will be easier? Which will make you more effective? If you had to reach the UN, if you had to reach the president, if you had to reach the governor, or if you had to walk down 3 blocks, knock on the door of your neighbor Susie. Have I illustrated my point? Sometimes local problems need local solutions. But I know what you're thinking. Hey, McGinley, you picked the pothole. You know, who's going to want the UN to fill potholes? So as our semester progresses, what I'm going to ask of each and every one of you, and hey, just to make sure you're motivated to do it, I'm going to grade you on it. You've read the syllabus, right? Graded essay, right? What's the topic of the graded essay? Subsidiarity. Subsidiarity about what? Well, that part you get to decide. We're going to continue throughout the entire semester. I said we're going to continue throughout the entire semester. Who shut off my big board? I tell you. What's a guy got to do to get a computer to work?
It's back up. Right.
Hey, there you go. All right. As we continue throughout the entire semester, I'll give you the choice. You pick the topic, and you explore these issues of subsidiarity. And you can do that. Subsidiarity is a principle that respects human dignity. It respects harmony. It respects the common good. And how does it do that? As individuals, we sometimes act alone. But no man is an island. No man stands alone. We tend to gather in groups. We tend to do this, in particular, in democracies where folks can vote. When a democracy is functioning properly, we know that we can get like-minded individuals together to vote in a particular way. That makes a difference. But subsidiarity is more than just voting. Subsidiarity means that the problem need not be addressed only in its highest ranks. Subsidiarity respects human dignity by allowing individuals who are closest to the problem to have the authority to address that problem. Some problems, we need to address them at the federal level. Again, to try to pick an example that no one would argue with me about, what if another nation declared war upon our nation? Would you want Orange County to raise an army? Would you want the state of Florida to raise an army? Or would you want the United States Army, Navy, Air Force, Marine, Coast Guard, Space Force? May God bless all of those individuals who serve our country. Those are the people we want defending us if, God forbid, another nation declared war upon us, right? So there are problems that are best addressed on the federal or national level, and subsidiarity does not dispute that. But subsidiarity says that that isn't the only level that should have power. If you've been in a corporate situation where there are middle managers, sometimes you see middle managers that have power and they can get things done. And sometimes you see middle managers that are micromanaged by higher levels. And that stymies middle management, does it not? So you've seen subsidiarity in your own personal experience. There are problems best solved at lower levels. One of the issues we will discuss in this semester is sexting. If you don't know what sexting is, it's in my textbook that I wrote for you. So you'll learn. But for those of you who already have a familiarity with sexting, and you need not raise your hand, how best do we prevent our children, our minors, our brothers and sisters who are under the age of 18 from sexting? Is this best done at a national or even state level? Will we prosecute those who are under the age of 18, label them as sexual offenders for the rest of their lives, force them to register and inform their neighbors as they grow older, as they become in their 20s and in their 30s and in their 40s and in their 50s and in their 60s and in their 70s, force them to inform their employers at age 60 that 50 years ago they sent it. Is that the best way to regulate sexting? Or perhaps should the family be involved and make sure that the children are not involved in sexting? What about our professions? What about the guilds? What about the unions? What about the bars? Personally, I'm a member of the Florida Bar, I'm proud of it. I'm a member of the District of Columbia Bar, I'm proud of it. Who's best to determine the rules of ethics, the rules of professionalism for Florida lawyers? Is it fellow Florida lawyers? Or should that be an act of Congress? Or should the United Nations declare how a Florida lawyer behaves? What duty of confidentiality I owe to a client is different under the rules regulating the Florida Bar versus the rules regulating the DC Bar. Should I have to keep track of these differences? I'm the member of both bars. Should they be different as we travel throughout the nation? Sometimes different environments, different situations, different facts about a locality require a different solution. Sometimes by exploring a different solution, a community, a locality, a state fails. Sometimes it succeeds, and that success then can be duplicated throughout the nation. Either result, success or failure, offers a lesson to the rest of society that can be learned vicariously if we respect the concept of subsidiarity and the fact that human dignity is not lost simply by humans gathering together in voluntary groups. Harmony can still be achieved despite subsidiarity, and the common good can certainly be achieved. Yes?
So when you're talking about raising an army, and you said there was really no reputation for that, and the federal government should be the one that does that, wouldn't it be in the best interest of human dignity, harmony, and common good that a man from Orange County raises an army from Orange County to fight for Orange County?
I love your argument, and I invite you to explore it in your graded essay. I'd love to read that. I can see the pros and cons of each. I can see how economies of scale might lead to a national army having more or better equipment than a local army. But I can see the argument that you might want to make that a local army might be more responsive to its fellow citizens. I'd love to read that essay. So to answer your question by dodging it, I invite you to write that essay. And that issue, like many involving the issue of subsidiarity, may not have a clearly right or clearly wrong answer. It may be a matter of degree. It may be a matter of opinion. I would love for you to explore those degrees and to share those opinions with me? Because subsidiarity is something that I've enjoyed, and it is a running theme throughout all of my academic and my practitioner writing. Back when I was in law school, I wrote this here. This is called Beyond Healthcare Reform. Wasn't that ambitious of me? The year's 1995, and I'm writing an article called Beyond Healthcare Reform. As far as I know, since 1995, we still haven't gotten beyond the issue of healthcare reform, have we? But I was talking about specifically there something called a certificate of need, a CON. This is a permission from a government to build a hospital. Here in the state of Florida, like in many states, you can't build a skilled nursing facility. You can't build a hospital. You can't add an ER to your existing hospital. You can't add beds to your existing hospital unless the government decides that that ER, those beds, that facility is needed and gives you permission to open it. Is that good or is that bad? I explored it there. And in so doing, I was touching on issues of subsidiarity. Later in 1999, I wrote this book, Florida Workers' Compensation. I've been updating it every year ever since. It's now published by Thomson Reuters Westlaw. You can find it in some database on the Westlaw database, or you can buy it in print for a mere $1,400. It's a 2-volume, 4,000-page book. And for those of you suffering from insomnia, it's guaranteed to cure it. And from that book, I wrote part of a shorter book, Florida Insurance Law. But again, I not only tell practitioners the nuts and bolts of how to practice in these areas, but I explore the fact that an adequately functioning insurance system can be part of, even the largest part of, that social safety net that individuals need, that it can be outsourced, if you will, or can be privatized, if you will, that it can be part of not the government, but of the private sector, and still meet those needs. Again, exploring subsidiarity. My best-selling book, and I thank all those who buy it because it helps me pay my mortgage, Florida Elements of Inaction, just had a simple goal there. I wanted to identify, clarify, and classify every cause of action existing in Florida law. I've been at it for 14 years. I'm not nearly even close to getting them all in there, but I'm up to about 2,000 pages so far. And in so doing, I'm helping to explore how Florida addresses these particular lawsuits and claims. Subsidiarity. Florida municipal law and practice is what helped bring me here. Municipal law is state constitutional law in action. Municipal law is county governments, cities, ordinances, which are local laws. They affect us on a day-to-day basis. We will touch upon them in this survey class, and they certainly give rise to issues of subsidiarity. And about a year ago, I published this in a law review. This was talking about a topic that is one of our chapters in the book. This talks about a particular use of the due process clause. And issues of due process certainly give rise to subsidiarity. So if you have an interest in due process, your essay can be about that too. But those are just some of the examples. The beauty of subsidiarity is what I describe in chapter 1 as the laboratory of democracy. I alluded to it earlier when I said that if we respect subsidiarity and the power of local and state governments to enact laws, then they might succeed or they might fail. But either way, that experiment in that law takes place in that laboratory and helps to guide the rest of our nation as to whether or not that was a good idea. In my last law review article on the previous slide, when I talked about due process, I talked about a particular area that looked a lot like substantive due process that was embodied in the constitutions of 23 states, ours included, and whether or not that was a good idea. So that's this concept of a laboratory of democracy that you see explored in my textbook. And before we take our first break, because I do give you a break. I know it's a 2-hour lecture, but there will be a break. Before we take our first break, let's take a look at our first case. And that is State versus Horowitz. You'll find that if you're following along on paper, somewhere in this chapter. I'm going to find it. There it is. Okay, State versus Horowitz. So what's going on in State versus Horowitz? State versus Horowitz, as you can tell from the name, is a criminal law case. I've practiced a lot of things in my 25 years as a lawyer, but never criminal law. I made that decision when I was in law school, and I took a criminal law class. I didn't get the book award in that class. I did get the second highest grade. And despite some professor telling me I was good at it, I decided that if you're going to be good in criminal law, more likely than not, your clients were going to be criminals, and I didn't want to represent criminals. So for those of you who do fight the good fight on behalf of those criminally accused, I applaud you, but I'm not joining you. It's not my thing. Everybody's got a thing, right? It's not my thing. What's my thing? I'm your friendly neighborhood bar grievance defense attorney. What's a bar grievance defense attorney? My fellow lawyers who are having an ethics investigation or are facing a bar complaint, alleged professional responsibility violations. I defend my fellow lawyers against the Florida bar or the District of Columbia bar. I fight the bar. So my clients are not criminals. They are wrongfully accused of ethics violations. That's very, very different. It is, it's different. It's what I do. Everybody's got to do something, right? So, State versus Horowitz. Miss Horowitz is not a lawyer. She's not accused of an ethics violation. She's a fellow Floridian. She's accused of criminal violation. Here's the deal, though. The evidence against her includes her silence before she was arrested. Okay, so this was not a custodial investigation for those of you who are into the criminal law. I'm not. I'll try to speak your language, okay? This was a non-custodial questioning. Specifically, this was pre-arrest and, therefore, pre-Miranda. That sound familiar? Whether you're into criminal law or not, if you're going to take a bar exam, please know the word Miranda, okay? You're laughing. Yeah. If you don't know that, don't plan on passing anybody's bar exam. So we're talking about whether Miranda versus Arizona is going to allow Ms. Horowitz's pre-arrest silence to be used against her. And as I edit the case, I take out the facts of the case because I'm trying to look at the substance of the state constitution. But maybe you can conjure in your head some sort of pre-arrest, pre-custodial silence. Perhaps someone's having a peaceful protest and is walking away from the peaceful protest with a large flat screen television under her or his arm, walking away from the peaceful protest as behind them the TV sales shop's windows are broken and maybe even on fire. So the policeman says, "You better show me a receipt for that TV." And instead, the person laughs and runs the other way. That's just one example, perhaps, of pre-arrest, non-custodial silence on behalf. And I'm not accusing Ms. Horowitz of that, but just as an example. Those of you who are familiar with Miranda versus Arizona, familiar with that Supreme Court of the United States SCOTUS decision, would that prevent the officer from testifying to that silence? Would Miranda keep that out of evidence? You say no. Raise your hand if you believe the answer to be no. Raise your hand if you would like to be correct here, because the answer is no. Miranda versus Arizona would not prevent that from going into evidence. But that's not the question of State versus Horowitz, a decision of the Supreme Court of Florida rendered in 2016. The question there is, will Florida's Constitution exclude that pre-arrest non-custodial silence. If Ms. Horowitz doesn't take the stand, doesn't testify at trial, will Article 1, which is our Florida Constitution Declaration of Rights, that's right, baby. When it comes to constitutional rights, we ain't got them tacked on as 10 amendments. No, my friend. Right there, front and center, page 1, Article 1 of Florida's Constitution, we're spelling out rights. Some of which are kind of not good, but we'll get to that in a minute. But anyway, we're spelling out rights. So Article 1 has got a Declaration of Rights. Can that protect Ms. Horowitz? The pertinent provision of Florida Constitution, Article 1, Section 9 says, quote, no person shall be compelled in any criminal matter to be a witness against oneself. This right has been referred to interchangeably as the right to remain silent or the privilege against self-incrimination. That language sounds a lot like the text of the U.S. Constitution, which I know you're not familiar with because your federal common law professor never asked you to read the Constitution. But it sounds a lot like the language of the federal Constitution. Indeed, we talk about a federal constitutional right to remain silent, do we not? We talk about a federal privilege against self-incrimination, do we not? First thing to note, just because the text of a state constitution's language is similar to or even identical to the federal Constitution, that does not, N-O-T, does not compel the state's high court to interpret the state's constitution consistently with the federal Constitution. Got that? What if my state literally went to a word processor and copied and pasted a federal constitutional right into my state constitution? Does that mean my state constitution, remember, it's copy and paste, it's verbatim, it's identical, it's unchanged. Does that mean my state constitution must be interpreted consistently with the federal Constitution? No. No, it does not. It's the first lesson of State versus Horowitz. To quote from it, these rights curtail and restrain the power of the state. Supreme Court of Florida is saying that Article 1, the Declaration of Rights in our state constitution, quote, curtail and restrain the power of the state, end quote. That's the second lesson, the second thing to know, the second takeaway from State versus Horowitz. It's often said, and if you spit this out into your Florida bar exam essay, they'll give you a point for it, that a state constitution, unlike the federal Constitution, is a restriction upon power, not a grant of power. Believe me when I tell you that if you memorize that statement and spit it out verbatim onto the essay of the Florida bar exam, they will give you a point for that. And the statement reads as this: a state constitution, unlike the federal Constitution, is a restriction upon power, not a grant of power. The state constitution, unlike the federal Constitution, is a restriction upon power, not a grant of power. There's just one thing you need to remember about that sentence other than, if you repeat it verbatim on the Florida bar exam, you'll get points. There's one other thing you need to know about that sentence. It's not true. It's not true. Nobody questions me on that. We'll explore that in greater detail in this class when you'll see parts of our Constitution granting power. I'm referring to Florida's Constitution. You'll also see at the end of this very chapter 1 where I explain that that sentence is only truly accurate when you're talking about the inherent power of the state's legislature to enact legislation that is not in violation of any of the panoply of federal rights. But for now, there's your sentence. Write it down, forget about it, And then before you take the Florida bar exam, spit it back out again, and then forget it again. That's the second takeaway. The third takeaway from State versus Horowitz is that Ms. Horowitz is granted by the Supreme Court of Florida, not the Supreme Court of the United States. Ms. Horowitz is granted by the Supreme Court of Florida a greater right than the U.S. Constitution embodies. It works like this. In our federal Constitution, we have rights that are guaranteed to all Americans. In our state constitution, we have rights that are guaranteed to all Floridians. The federal constitution, you may think of, and State versus Horowitz describes as, a floor, by which I mean a bare minimum, by which I mean the least. So you have at least, as a Floridian, all the rights that Americans have under the panoply of federal laws. The state constitution can grant Floridians additional rights, but not to the detriment of the full panoply of federal rights, because the federal rights are the minimum. They're the floor. I hope you can picture that, but if you can't, then I'll make light of my own lack of skinniness. All right? Remember me, the fat man, okay? And remember this floor, because no matter how high the fat man jumps, he's not going to crash through this floor. As I stand here on the cement floor, it doesn't matter how much I jump, I'm not going to crash through the floor. And that's what I'm trying to illustrate. This floor is the federal constitution and the full panoply of federal rights granted to Americans under federal law. And as heavy as the state constitution might be, or no matter how high it jumps, it will never crash through that floor. That's how the system works. That's the takeaway of State versus Horowitz. You notice in our text, I provide you with some notes and questions to consider. So let's do that. But before we do, let's take a 10-minute break. Sound good? All right, it is, I got about 2 minutes till 7. We're out of here at 7:43 or something crazy like that. 7:40, 7:38, 7:36, 7:35, 7:35 going once, 7:35 going twice. Sold! All right, I'll see you back here in 9 minutes because it just wasted a minute. And then we'll be out of here at 7:35. Sound good? All right. Hey, how you doing? Oh, okay. Sorry about that. I wanted to put it in the packet for everybody to use, but they're just not.
They're not doing any training.
No, I think they are, but she just got lost. She's like, really.
I mean, the thing you said about each and a half.
She's one of those.
Yeah, no, I understand.
Chapter one's pretty short. I think it's easy insofar as it's quick. So it shouldn't take too long. Yeah.
Sorry.
That's all right.
I'm trying to catch up on what's live.
That's all right. All good.
I forgot to sign your attendance. I'm gonna do it.
That means you're not here.
I know.
On the flip side, if you sign it, you were here. So that's the beautiful thing, right?
I'm looking at on your website now.
Yeah.
I hate split screens. It is cold in here.
I know. I'm glad I got the jacket because it is cold in here. Yeah.
Sometimes you don't like me work here. Okay. What page you on? Oh, wait. Go back. Right there. Where am I? Where are you? I literally told, I mean, I said, that was too late.
Well, I'm kind of a little quick, but one of the classmates, depending on the YouTube, was asking if there's a way to communicate. I assume the answer is no, to communicate. Carrier pigeons. Well, I mean, I know it could fly in the door, right? With strapped to its bill. What's that? Claw? Well, what's a pigeon? What? Yeah, I can hear them raise their hands, but I guess I don't know if she was trying to talk or not. It's probably the slow thing saying so. Yeah, I don't really. Sorry. No, it's the question I do have in relates to me is, so I'll be here, but if there's ever instance where I can't. Well, yeah, if everything's on the second shoot, then you were here. Okay. Or maybe you'll be one of those people who 20 minutes after the lecture is still watching it. I don't know. No, I only had one professor ever do that to me. I won't tell you who, but actually it's kind of frustrating because I told him, I'm still actively listening, but I have to step away from the computer. So I left it on and I came back and there's like 3 of us, and I'm like, why would you do that to me? I was stepping away. So, oh well. I see it like a concert. Like, you know, go by and go to the show and go to the show. What's the band? That's all I see. I don't know if you're noticing, like one of my classes on being conveyed, I wouldn't know. Well, the professor was,
Oh, yeah.
That he said it wouldn't, but he was clearly testing
I don't
whether
know,
he
the
was
only
doing
thing
it
I
just
can
chat or
see that
so his exam basically mirrored
No,
the
just
question.
saying.
And what he said was, there were half the wrong, because the shot was clearly but he said a number of them didn't even, I guess they can see when you sign in online, you can test online. And I even told a friend of mine, a lot of my kids,
I really do.
wouldn't sign in on this shot. Automatically, It blew my mind. Yeah, that would blow my mind too. I'm like, dang, there's all this money. You might as well take that. At least click something. Yeah, I don't know. I don't know what to say like that. That blows my mind too. I don't know. I mean, it's a crowded field, so I mean, less competition, the better. You'd be better. I mean, that's it.
Yes, I did.
I feel like I got the answer.
No, we were actually independent citizens were having a debate about which book was the right book. So, but
Did you make it right now?
I just waited in surprise. I was like, I didn't have it. But this is the problem that I'm doing.
Oh, yeah, this is an outlook thing.
She would ask.
Really?
So, is there any other way?
I feel like Constitution.
It's not. Yeah. It's a lot of things.
She made the right papers that day. I was like, oh my God.
Yeah.
It just
Every
keeps
5 seconds, yeah, that line.
Oh,
I put verbatim and she said it.
but this, I guess I could use this one. Hold on, let me see.
I was like, I put verbatim what I heard.
Yeah, I even Googled it and it brings it up like it's still, the site is good or whatever, but
Yeah, I had it up this afternoon. Oh, there we go. Okay. Gotta find it now.
Yeah, just oh yeah, oh my one
Oh,
color.
okay.
or not.
I had it this afternoon, but I got this.
I've already forgotten all these things.
Yes.
Workers' comp, you don't care whether you came in or not. They're like,
It came up on my phone, but it won't let me sign the Google Doc on my phone.
oh my, like, saw one person too. I was so proud of myself. That's how I felt like. That was the hardest final ever. It wasn't very. I literally, when I was doing the final, I was sitting there and I was reading, like, you could choose 3. And one of the questions I read, and I'm like, I know.
Oh, okay.
And I know the scenario is wrong, but nothing is coming to mind.
I'll send you.
I didn't have time to do it. I didn't do it.
I think it's because it might be on the website.
That's probably true. I didn't buy it.
Right, so
But like, I
I'll
ran
send
out
an
of
email
time.
to I have to get it.
I like finished it.
I just CC you on it. No problem.
I think that was my best class last semester, and I was so shocked. Copyright wasn't bad.
Yes. And remember, the state sit on that point.
I did my time in New York and Chicago, bro. I would.
I would
I thought it was a lot, but I didn't know.
I'll then be 19 and the heater freezes over. I'm like, I don't need this.
Right.
Hot chocolate doesn't make you warm.
I'm back.
Yeah, I'm a little Christian.
Yes.
Do you have any extra copies of the book directly?
I'm sorry. No. Thank you for asking. Yeah.
You might have it in your trunk or something.
I got this one. That's all I got. All right. Okay, so we are back. Thank you for coming back. We left off with State versus Horowitz, and we're talking about these notes and questions to consider. Question 1 read as follows. What greater protection for Ms. Horowitz did Florida's Constitution provide that the federal Constitution did not? And remember, this case, State versus Horowitz, goes farther than Miranda versus Arizona in granting greater rights. Specifically, we're talking about that non-custodial silence of Ms. Horowitz. She was the defendant in a criminal matter. It was a pre-arrest, pre-Miranda, pre-being read her rights, silence, and it could not be used as substantive evidence of her guilt, even though she did not testify on her own behalf. That wouldn't have been the result merely by applying Miranda versus Arizona and its progeny. That would not have been the result merely by applying the Constitution of the United States. That was only the result because of the Constitution of Florida.
So that was an example of greater rights for a Floridian than Americans as a whole. That's the answer to question 1. Question 2, is Florida's Supreme Court in State v. Horowitz attempting to overrule the Supreme Court of the United States decision in Miranda versus Arizona? Does State v. Horowitz hold that the federal constitutional interpretation in Miranda is wrong? Is that the holding? You're shaking your head. You're saying no. Who wants to raise their hand and agree that the answer is no? Because if you raise your hand, then you would be giving the right answer. The answer is no. This is not an example of the Supreme Court of Florida disagreeing with the Supreme Court of the United States. This is not an example of a rogue court saying, I'm going to disobey the Supreme Court of the United States. That is not what we see in State versus Horowitz. What we see here is fidelity, is obedience, is application, is true, is interpreting accurately Miranda versus Arizona. But laying on top of that an additional right, not found in the U.S. Constitution, not found in the holding of Miranda versus Arizona, not found in subsequent SCOTUS decisions interpreting Miranda versus Arizona, found instead in the Constitution of the state of Florida as interpreted by our state's high court, the Supreme Court of Florida. So that's the answer to number 2. Number 3, explain how the concept of a, quote, laboratory of democracy is promoted by this sentence. Quote, put simply, the United States Constitution generally sets the floor, not the ceiling, of personal rights and freedoms that must be afforded to a defendant by Florida law. How's that the laboratory of democracy? And the answer is this. By interpreting a state's constitution to grant even more rights to a state's citizens than can be found in the federal constitution and in federal law, a state becomes a laboratory of democracy by experimenting with greater rights, never in that experiment granting any less than the floor, never denying any state citizen any of the full panoply of federal rights, but while respecting all the federal rights, granting in addition a state law right. That's what we're talking about when we talk about the laboratory of democracy. Laboratory because it's an experiment. Experiment because it may turn out beautifully or it might blow up in your face. And very shortly in this very lecture, we're going to look at an example of blowing up in your face. Laboratory of democracy. Number 4, must a Floridian exhaust her federal constitutional rights before turning to Florida's Constitution for protection? And I answer that question for you in the very next sentence there. Consider this sentence from State versus Horowitz, quote, when called upon to decide matters of fundamental rights, Florida state courts are bound under Federalist principles to give primacy to our state constitution. If you look at the plain language of the State for Horowitz decision, you will see that the state court turned first to its state constitution. This is an example of primacy, by which I mean a state court turning first to its state constitution and then turning to the federal constitution. Primacy can be how a given state court's opinion reads. Primacy means that we turn first to the state constitution and then to the federal. Primacy can work if we understand that the full panoply of federal rights from whatever federal source are a bare minimum. Primacy works if we understand that the state constitution might add greater rights on top of that bare minimum. Therefore, if we start with the greater, we find the right, we don't have to start scraping the bottom of the minimum in order to find that right too. We already found it. So primacy can be the solution. And State v. Horowitz, as reprinted in my text, certainly is on its face an example of primacy. Mike, you've got a question.
Yeah, earlier, when you gave us the sentence for the bar exam, that the state constitution and like the federal constitution is a restriction of all power, not a ground power.
You said it correctly. Write that verbatim on your bar exam. That you nailed it. Well done. But I interrupted your question. Go ahead.
When you said that initially, my mind kind of went to the point that what you came to, which is that the constitutional powers or federal powers are flawed. So are you saying with that restriction, is it a restriction upon the state or is it a restriction upon the individual?
It's a restriction upon the state. That's the answer to your question. But it's only part of the answer to your question. Because even though that is the answer to your question, as you dive deeper, you find that the sentence falls apart. Remember, there were two things to remember about the sentence. First, be able to quote it verbatim so you can regurgitate it. I choose my words wisely because it really is garbage. You're regurgitating it onto the Florida bar exam. But then forget that sentence because it falls apart. Mike, it falls apart, man. If you at least throw in the word legislature as restriction upon legislative power, it has more truth than it does without that word, but it still falls apart. And my textbooks tries to give some examples of that. For example, say you're pulled over by a policeman, all right, maybe a state trooper. And the state trooper honestly believes, and the state trooper is 100% correct, that his agency budget is running out. His agency needs money, right? So can he just take your money? Not for himself, for the agency, right? No, can't do that. And that's true regardless of the sentence that we're all regurgitating here about the state constitution being a restriction upon power, not a grant of power. And the examples go on because the truth of the matter is that what we have in our federal system is not a nation of people, it's a nation of laws. What we've got is due process. What we've got is a system where if the government has the power to do something, there's got to be an enabling statute. There has to either be an organic source of law, such as found in a constitution, be it federal or state, or there's got to be legislation that allows that to happen. So it is simply too simplistic to say that one constitution, the federal, is a grant of power, nothing more, and another constitution, the state, is a restriction upon power, nothing more. Because when we look at the text of each constitution, and I know you took federal con law and nobody bothered to look at the text of the federal constitution. That's not how I teach this class. But when we look at the text of either constitution, the federal or the state, we can find examples of restrictions and grants. Grants and restrictions, they're both in there. So Mike, I share your frustration with that sentence. You are correct in your analysis. But if you want a free point on the Florida bar exam, you'll want to regurgitate. Yeah, just after that, don't try to use it in a court of law.
Because the state constitutions are filling in the holes that the federal constitution didn't fill. And then as you go down, at least that's how I was understanding it.
Okay, I'm going to come back to that. And I'm going to ask you if you still agree with that. Because you're talking off the cuff and you're saying that the state constitution kind of fills in the holes in the federal constitution. Let me come back to you in a few minutes. And let's you and I explore that and see if we still agree with, I know you just said it off the cuff, but let's take a look at that sentence too and see if we can find, like the prior sentence, some flaws in that one. But let me get back to that. Let me finish up the notes and questions to consider. Number 5, last one. How would you describe the relationship between the federal constitution and state constitutions? And Mike, now back to your question, because it's here. One of the potential ways, and let's explore it, let's see if it's the right answer, is that the federal constitution leaves us like a piece of Swiss cheese. It's cheese, but it's got holes in it, right? You want more of a Munster cheese. You know, Munster doesn't have those holes in it, right? So you slap on a state constitution and you turn Swiss into Munster. Boy, that really paraphrases you, Mike. You didn't mention anything about cheese. I'm cheesier than you are, see? I'm cheesy. Easy. All right. So is that how it works? Is a state constitution a supplement to the federal? Is that the answer? Are they co-equals? Is that the answer? Is a state constitution a redundancy? Is that the answer? Is a state constitution a way for a state to reject federal law in whole or in part? Is that the answer? Are none of these statements accurate? Let's go in reverse. Is a state constitution a way for a state to reject federal law in whole or in part? No, 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 no. No. The next section of this book asks this question. Can Florida's constitution be unconstitutional? Can the state constitution be unconstitutional? Spoiler alert. Yes. Yes. State constitution can be unconstitutional. Spoiler alert. So a state constitution is not a way to reject federal law in whole or in part because it wouldn't work. Wouldn't work. Is a state constitution a redundancy? It can be, but it need not be. Remember one of the takeaways from State versus Horowitz. Even if I were to literally open up a word processor, copy part of the federal constitution and paste it into my state constitution and enact it as part of my state constitution, I'm still not bound or forced to interpret that verbatim copied language exactly as it's interpreted in the federal constitution. So that's not the answer. Are they co-equals? Well, one can render the other null and void. Federal law and federal rights, the full panoply of federal rights, can render even the state's highest expression of its law, its organic expression, its state constitution, can be found null and void or unenforceable or unconstitutional based upon federal law. So are they co-equals? No, they are not. Is a state constitution a supplement to the federal? And that's an interesting one. You studied contracts, right? What if you and I sit down and write a contract? And then a few months or a few years later, with reference to the prior contract, you and I write a second supplement agreement and sign it with all the formalities of the first. What does that second supplemental agreement do to the first? Changes it, right? So is that how it works? Do I look at the federal constitution? Okay, 1789 plus amendments. Then I look at the state constitution. Okay, Florida, 1968 plus amendments. Oh, 1968 was after 1789. Therefore, that changes the federal constitution. Is that the proper analysis? No. Maybe in a contracts class, when we're talking about contracts, that might work. In a subnational constitutional law class like this one, that's not how it works. That's not how it works. Is a state constitution a supplement to the federal? Does it cover up the holes in the Swiss cheese? In very many instances, yes. So Mike, again, you're right, but with exceptions. In very many instances, yes. Certainly we can't nullify or contradict federal rights even with an enactment in a state constitution. But to the extent that we think something should be applicable to all Americans, but isn't, we might write that greater right into our state constitution and therefore grant greater rights to a Floridian than the Floridian has as an American, so long as what? So long as the fat man doesn't crash through the floor, right? So long as we do not deny Floridians the full panoply of federal rights. Answers your question, Mike? Did I answer it?
Yeah.
All right. Now, with that said, let's go to part B. Can Florida's constitution be unconstitutional? And you remember the spoiler alert. The answer was yes. Florida's constitution can be unconstitutional. Thanks, McGinley. Got any examples for that? You betcha, Chief. I got them. Article 1 is our Declaration of Rights. Can you believe that there was a time that Florida's Constitution in Article 1, page 1, on what's called the Declaration of Rights, actually said that Florida's legislature has the right to enact laws to deny Asian Americans the right to own, buy, sell, or inherit real estate, real property here in the state of Florida. Gosh, that's disgusting. That's offensive. That's immoral. When was that in our Constitution? Well, from the 1860s through 2018. 2018. I'm talking about 2 years ago. It was in there. It was in there. Oh, it's because nobody noticed it? No, they amended it. They added it there. There was even an attempt, the first of 2 attempts, to strike it and delete it. And the voters of the state of Florida said, no, let's leave it in there. It wasn't until the second time they tried to delete it in 2018 that the voters technically said yes. And why do I say technically say yes? Because that deletion was bundled with 2 other things on the 2018 ballot. And to vote for the 2 other things, you also had to vote to take out the racist, disgusting alien land law, which is what I'm talking about. This law that empowered, allegedly, the Florida legislature to deny our Asian American brothers and sisters the right to buy or sell or inherit real estate, real property. 2018. That's not ancient history. Yes.
I read that, but I do have a question. It looks like it wasn't gotten rid of until 2018. There's no way it could have been enforced. I mean, I've got
Correct. Correct. There's no way it could have been enforced. But why not? It's in the state constitution. Why can't I enforce it? You're right, but tell me why you are right. Why are you right?
Well, aside from the fact that it's against the federal constitution.
Thank you. Thank you. What do you call language or parts of our state constitution that violate federal rights? In this example, that violate the federal constitution. You call them unconstitutional. The question is, can Florida's constitution be unconstitutional? And as you know, the answer is yes. A second example. This one strikes right to the heart of me. Sectarian. What does sectarian mean? Both history and opinions of the Supreme Court of the United States tell us what sectarian means. It means Catholic. It means me. It means Catholicism. Our state constitution today, and it hasn't been amended. It hasn't been taken away. Our state constitution of Florida, like many other states, continues to say that we can't have any money coming out of the state legislature or the state coffers that would benefit sectarian, in other words, Catholic schools, Catholic education, Catholic universities. As I stand here teaching in a Catholic university, and I'm teaching you about Florida's constitution, which says that because this university is Catholic, you can't use the state coffers, you can't use Florida money to support this institution because it's Catholic, because it's sectarian. Will Florida try to enforce that? I hope not. Have other states enforced that? Yes, they have. Is there an opinion pending before SCOTUS? I think there is. Am I hoping for a pro-Catholic outcome? Lord knows I am. I hope you are too, whether you're Catholic or not. Just because I'm Catholic, should I be denied? I hope you agree I shouldn't. My son's 11. My daughter's 7. They attend St. Margaret Mary Catholic School on Park Avenue in Winter Park. So if you don't have any sympathy for me, maybe you could have some sympathy for them. They did nothing to you other than be born of a mom and a dad that happened to be Catholic and send them to Catholic school. Please don't discriminate against them because of us. Another example, defining marriage. let's look at the text of Florida's Constitution. What's it say about marriage? I'm quoting from Article 1, Section 27. I'm not quoting from history. I'm quoting from today. Inasmuch as marriage is the legal union of only one man and one woman as husband and wife, no other legal union that is treated as marriage or the substantial equivalent thereof shall be valid or recognized, end quote. That's not my language. I'm reading to you from Article 1, Section 27 of the Constitution of the state of Florida as it reads today. Is that language enforceable? I have here on the big board 2 holdings from the Supreme Court of the United States, U.S. versus Windsor. It holds unconstitutional the Defense of Marriage Act. That DOMA, if you will, had an exclusion for same-sex couples, excluded them from the definition of marriage. That was an unconstitutional law according to U.S. versus Windsor. That 2013 opinion was followed by 2015. I hope I pronounced this right. Obergefell? Do I pronounce it right? Obergefell versus Hodges, Obergefell. 2015 holding that states may not deprive same-sex couples of their fundamental right to marriage. So that is a decided issue. That is the law of the land. So why is this language still in our state constitution? Where's the flying eraser? Have you seen it? The flying eraser, have you seen it? It's this big eraser with wings. Yeah, whenever SCOTUS issues a ruling, the flying eraser takes off and it flaps. And it lands on the laws that are unconstitutional and erases them, right? So you can't, see. Have you seen the flying eraser? No. Why is that? Because there's no such thing as a flying eraser. Doesn't exist. But can I enforce this? No. What do you call this language from the Constitution of the State of Florida? You call it unconstitutional, right? So the question was, can a constitution be unconstitutional? And I think we've arrived at an answer, right? Does Florida's constitution prevail over contrary federal laws? I need a scorekeeper. Somebody who can either add or not add to the score of 2 teams, all right? I'm going to have team 1, state of constitution, Florida's constitution. We're going to call that team state. Go state. Go state, go state. All right? We'll have another team and have federal. Boo hiss, boo federal. Who can be my impartial scorekeeper? Just counting balls and strikes, just adding them up. Who will be my scorekeeper? I will pick someone. If somebody doesn't raise their hand, well, it's an awful threat. But I'm going to do it. I like your mask, so I'll pick you. May I ask your name? Haley. Nice to meet you, Haley. I think I got an email from you.
You did.
I hope I gave a good enough answer. All right. Well, Haley, can you do this? Can you impartially count the balls and strikes, keep score for us? No bias. Can you do it? All right. Everyone thank Haley. She's going to keep score for us. All right. Now, if state wins, if the Constitution of the state of Florida wins, we're going to give it a point. If federal wins, federal prevails over state, we're going to give it a point. We'll see who gets the most points. Sound good? All right. So now, let's take a look at the scoreboard. The text of the U.S. Constitution says one thing. The text of Florida's Constitution says the opposite. Which one wins? I'll make a multiple choice, all right? Florida's Constitution wins. That's choice 1. U.S. Constitution wins. That's choice 2. But this is law school, right? There's always a spin, right? U.S. Constitution wins unless you are a Floridian. Oh, okay. That's choice 3. Choice 4, U.S. Constitution wins unless you are in a Florida court. I like that. What is the correct answer? Remember, the simplistic facts are these. The text of the U.S. Constitution says one thing. The text of Florida's Constitution says the opposite. And remember what Florida's Constitution is. It is the organic law of our state. It is our state's highest expression of the law. You can exalt a state law no higher than the Constitution. This is the almighty. This is the organic. So which one wins? Who can tell me? Yes.
The U.S. Constitution.
You suggest the U.S. Constitution gets the point. Who will raise their hand and agree? Who will raise their hand because they would like to also be right? That's right. That is the correct answer. Haley, give 1 point to the federal. 0 point to the state. With that added up, what's the scoreboard say?
0 Florida, 1 Constitution.
You heard Haley. She's impartial. Let's take another look. How low can we go? It's like limbo. Every limbo boy. How low can we go? I can't go very low. Okay. How low can we go is the question. Clearly, the text of the U.S. Constitution prevails over any state or federal law. But in order for a federal law to preempt a state law, how lofty and powerful must the federal law be? Huh? Interesting, right? What if the federal law was something less than the text of the U.S. Constitution? Remember the simplistic facts of our last slide? It was the text of the U.S. Constitution versus the text of the state constitution. But what if we're not talking about the text of the U.S. Constitution? What if we're just talking about another source of federal law? What sources of federal law are powerful enough to overcome a state's highest and most powerful expression of state law, the state's constitution, in the battle between the state's constitution and a federal law? Which federal laws win? Haley, keep that scoreboard coming because we got some more matchups. You ready? Ready for the next matchup? Here we go, folks. Next matchup. The text of the U.S. Constitution is silent. It's not in there. I know you never bothered to read it in Con Law 1, but it exists. For our hypothetical, on this matchup, it's silent. It doesn't address the topic. But the Supreme Court of the United States, SCOTUS, renders an opinion on the issue. The text of Florida's Constitution contradicts SCOTUS. Which prevails? Choice 1, Florida's Constitution. Choice 2, SCOTUS. Choice 3, SCOTUS, but only if SCOTUS rendered its opinion before the text was added to the Constitution. Or choice 4, SCOTUS, but only if the text of the U.S. Constitution supports SCOTUS's opinion. Who can tell me what the answer is? Yes, Mr. Whalen, what is the answer?
Supreme Court.
So you say point to federal?
Yes, sir.
Federal wins? Raise your hand if you agree with Mr. Whalen. Raise your hand if you want to be right. That's correct. Haley, add another point to the board. Add it for the Fed. What's our score?
0 Florida, 2 federal.
0 Florida, 2 federal. Let's go to our next matchup. But remember this quote. Perhaps this famous quote from a U.S. Supreme Court justice said it best. And he's talking about the opinions of the United States Supreme Court. It's a SCOTUS justice talking about SCOTUS opinions. We are not final because we are fallible, but we are infallible because we are final. When SCOTUS rules, who do you appeal to? I hear silence, and that is the correct answer. There's no one to appeal to. You're raising your hand. You got someone to appeal to?
Well, I'm saying you don't appeal, but you could rewrite laws or amend them.
I like a man who finds a way to get the job done. Sure, yeah, you could amend the federal Constitution. Yeah, doesn't happen often, but it can be done. It can be done. Yeah, but that would be a rewrite of the Constitution. That would change the outcome. You could make the Constitution different and therefore change the outcome of a SCOTUS opinion. But that's not a direct appeal. When it comes to appeals, this justice said it best. He's infallible because he's final. Yeah. All right, here's our next matchup. Keep that scoreboard alive now. Neither the text of the U.S. Constitution nor any SCOTUS decision addresses the topic. The U.S. Congress passes a law on that topic. Florida's Constitution says the opposite of Congress's law. So this is a battle between not Florida's Constitution and the U.S. Constitution, not Florida's Constitution and SCOTUS, but Florida's Constitution versus Congress. Who wins? Choice 1, Florida's Constitution. Go state, go state, go state. Choice 2, U.S. Code. Choice 3, U.S. Code, but only if it states that it preempts state law. Only if Congress states in its law that it preempts state law. Or choice 4, U.S. Code, but only if a SCOTUS decision says it prevails. Needs SCOTUS to say it prevails. What's the answer? Which one of those 4 choices is correct? Correct answer is U.S. Code. Fed wins. Yes.
But how do you explain medicinal or like marijuana? It's against the federal code, but it's legalized in many states.
That's right. The states claim it to be legalized. What if in those states that claim it to be legalized, a federal officer were to arrest someone
They got to take it to federal court.
and they'd go to jail and they'd be convicted?
So it all just comes down to whether they choose to enforce.
Well, I guess one could argue that a law that's not enforced isn't a valid law. We have to choose. Are we a nation of people or are we a nation of laws? The question is, which law prevails? And the answer is, federal prevails. Can I get a rogue jury to not convict? I did it once and I've only had one jury trial. Can I get a rogue officer to not do the officer's duty? Could happen. Can I get a rogue state to violate federal law? Well, we're standing here in Florida where I'm pointing out language from our state constitution that's blatantly, clearly, obviously unconstitutional. But the question is, which one prevails? And in this fight between Florida's Constitution and the U.S. Code prevails. Haley, one more point for the federal. What's our score?
We got 0 for Florida and 3 for federal.
State 0, federal 3. Go state, go state, go state. Let's see what we can do in the next matchup. Next matchup, the text of the U.S. Constitution and SCOTUS and the U.S. Code, all of them are silent. None of them address the issue. But a federal regulation does. Familiar with the CFR? Familiar with the Code of Federal Regulations? Yeah, agency rules, right? Agency regulations. CFR, Code of Federal Regulations. I'm talking about one of those, all right? That Code of Federal regulation contradicts the text of Florida's Constitution, which prevails. Choice 1, Florida's Constitution. Go state, go state, go state, go state. CFR. Choice 2. Choice 3, CFR, but only if the regulation says it preempts state law. Or choice 4, CFR, but only if the statute that the regulation implements says that it preempts state law. What's the correct answer? Choice 2. Correct answer? Code of Federal Regulations. That preempts our state constitution. In a head-to-head battle between the Code of Federal Regulations versus the state constitution, the federal code, the Code of Federal Regulations, the CFR is the winner. Haley, one more for feds. What's our scoreboard say?
0 for Florida and 4 now for federal.
0 for Florida, 4 for federal. Go state, go state, go state. Let's look at our next matchup, okay? Text of the U.S. Constitution, silent, doesn't address it. U.S. Code, silent, doesn't address it. CFR, silent, doesn't address it. SCOTUS, silent, doesn't address it. No federal appellate court. None of the federal appellate circuits. No federal appellate court has addressed it. All silent. But there's a trial court, United States District Court. It has an order that addresses it. But Florida's Constitution contradicts the United States District Court. In this head-to-head battle between a federal trial court's order and the Constitution of the state of Florida, which is the winner? Choice 1. Oh, this reminds me that class is almost over. Gosh, you've almost endured 2 hours of me. Just 3 or 4 minutes left. Hang in there, folks. We got to know what the score is, right, Haley? We can't leave before the 4th quarter. We got to know the outcome of the game, right? Head-to-head battle. Did Florida's Constitution win? Did the U.S. District Court's order win? Maybe it's the U.S. District Court's order if it's based upon the text of the U.S. Constitution. Maybe it's the U.S. District Court's order unless the language of Florida's Constitution came first. What is the correct answer? The correct answer is the U.S. District Court's order. That's the correct answer. Haley, add 1 to the federal side for the scoreboard. What's our score, Haley?
0 for Florida and 5 for federal.
0 for Florida, 5 for federal. Go state, go state, go state. It's the 4th quarter. It's the 4th quarter. U.S. Constitution, silent. U.S. Code, silent. CFR, silent. SCOTUS, silent. No federal court, not even the trial courts, not even the U.S. District Court, has issued a ruling. But there's a federal agency. In fact, it is the lowest federal agency. In fact, it is the federal agency with the smallest budget. In fact, it's a mostly despised federal agency. In fact, when Congress is in joint session and the president and the vice president are there and all the agency heads are there, they leave this guy out. They don't even bother to tell this woman or this man about the meeting. I mean, this is an almost forgotten federal agency. Certainly not an elected official, an appointed agency head. And this appointed agency head with the power to exercise discretion contradicts Florida's Constitution. Go state, go state, go state. Who wins? Florida's Constitution? The federal agency head? Despised agency head. Ooh, low budget, low budget. The agency head, but only if her agency's rank is sufficient. Big budget, high ranking, in the cabinet. Federal agency head, but only if she was elected, not appointed to her post. What's the correct answer? Which one wins? Which one wins? The agency head. Haley, put one more on the federal scoreboard. What's the score?
0 state and 6 federal.
0 state, 6 federal. Okay, it's the fourth quarter. 4 seconds left on the clock. We're down 0-6. It's time for the Hail Mary pass. Send us into overtime. You ready? You ready? Okay, here's the matchup. U.S. Constitution, silent. U.S. Code, silent. CFR, silent. SCOTUS, silent. Federal agency, silent. But there's a federal common law decision. Hey, McGinley, didn't you read Erie versus Pennsylvania? No such thing as federal common law, right? No. Erie versus Tompkins eliminates almost all federal common law. It leaves a scant little bit, such as riparian rights, rights to water in a river, and disputes between states. So it doesn't wipe out 100% of federal common law. It's more like 99.999999999999998%. But there's a little bit there. That piece of common law versus the highest expression, the most noble expression, the organic law of the state of Florida. The Constitution enacted by the people. Which one wins? Go state, go state. Florida's Constitution or federal common law, or federal common law, but only if that law says it preempts state law. Which one wins? Fourth quarter. Hail Mary pass. It's in the air. The ball is up. It's coming down. The receiver has an eye on it and misses. Sorry, the answer is federal common law. Federal common law. Haley, one more point for the federal. What's the final score of our game?
0 state, 7 federal.
It's a blowout, ladies and gentlemen. 0 state, 7 federal. No matter how low I would go, federal won. Federal won. So that is a lesson learned. Indeed, you can see it implemented. If you read the book, you can see an example of the laboratory democracy where an experiment blew up. Blew up! I got a quote here from the Congressional Record, 1979. Sorry to go so far in the past. There's probably earlier examples. But this one talks about Arkansas and their senators asking the U.S. Congress to pass a law that contradicts their state constitution. Their state had an experiment. It was a usury law. Usury laws say you can only charge a certain maximum interest rate. They picked so low a rate that you couldn't get a loan anymore in Arkansas in 1979. You couldn't get a mortgage to buy a house. You couldn't get financing for your business. You couldn't buy a car because the highest interest rate was so low that no bank, no lender, no one, nowhere, nobody, nothing, no one could lend money at that rate and make a profit. So what did the senators do? They asked Congress to pass a law that contradicted their own state constitution. Why? Because which one wins? Right. There, my friends, is the safety net. The laboratory of democracy has a safety net. States are free to experiment with greater rights. And if the experiment blows up, the floor is there to hold them up. That's the lesson from today. But here's a question to take home for the next week. And we'll think about when we come back. If any old federal law is better than state law, how can I have state law precedent? What good is a state court decision? How can I issue a state court decision that can be upheld? What are the criteria for denying the Supreme Court of the United States jurisdiction to overrule my state court precedent? Despite this scoreboard, despite this truth, despite this reality, I'm going to empower you. I'm going to teach you how to arrive at a state court decision that even the Supreme Court of the United States cannot overturn. I'm not saying that I will give you the persuasive arguments to persuade SCOTUS not to take jurisdiction. No, more than that. I will teach you how to illustrate to SCOTUS that it lacks jurisdiction, that it does not have jurisdiction, that regardless of how it feels about the state law decision, it can do nothing about that state law precedent because it is powerless and it lacks jurisdiction. Can the Supreme Court of the United States lack jurisdiction? Can I empower you to make an argument that the Supreme Court of the United States lacks jurisdiction and for you to be correct and right about that argument? Yes, I can, and I will do it in 1 week's time. I'll see you then. Thanks for being here tonight.